Hi. So let's quickly talk about the law of confidence. I don't know if we talked about it before we went on strike, but let's just go through it because it's also important. It's one of the intellectual property rights, and it's very important that we know about it. Okay. The law of confidence, basically, in layman's sense, protects information information that has a confidence about it, information that's supposed to be a secret. That's what the law of confidence protects. It says here that it's concerned with the protection of secrets, whether they are trade secrets. These trade secrets are usually business, business secrets that can be sold or licensed or to get value. That's what trade secrets are. Also, law of confidence is concerned with trade secrets or even secrets of a personal nature, and then secrets concerning the government of a country. You know what I mean by secrets of a personal nature? Your own secrets. Maybe you have a secret, and then you now go and attach a law of confidence to it because you don't want it to be told to any other person. You don't want it to be exposed or spilled. Okay, so the law of confidence is very important, and it's why it's quite important because people also add it, like you want to apply the copyright law to something, you can also back it up with the law of confidence. So law of confidence usually acts as an addition to other intellectual property rights. So there's a difference between the copyright law and the law of confidence. We've talked about copyright law. If you remember, copyright law protects the expression of an idea. But the thing about law of confidence is it protects that idea itself. So that's the main difference between the two. So you can now combine the two of them to have a very powerful protection of the thing you want to protect. So for an information to be breached, like the confidence of an information to be breached, there are three things that have to take place before you can say the confidence has been breached. One, the information must have the necessary quality of confidence about it, meaning that information itself should be a secret. It should have been a secret, because if it was something that was not a secret that everybody already knew, then you cannot say somebody breached the confidence of it. Second one, the information must have been imparted in circumstances importing an obligation of confidence, meaning that the way that information was shared to the next party, it should have been like you know how we tell somebody something, I say don't tell anybody. Don't tell anybody. So it's in that setting. So you must have told the person, look, this thing I'm telling you is supposed to be between me and you. I don't want to hear it anywhere else. You have to swear an oath or something, swear that you will not spill it. So that's just basically what the second requirement is trying to say. It should have been parted in such a way that it was kept secret before it was now breached. Okay, then the third one, there must be an unauthorized use of that information to the detriment of the party communicating it. So that's the third one. Okay. Now, to be protected by the law of confidence, okay, for an information to be protected by the law of confidence, the information itself must have the quality of confidence about it. That's what we said. If the information is commonplace, or if the information is common knowledge, everybody knows about it, in public domain, it cannot be protected by the law of confidence. So that's one thing you need to know about it, okay, about this law of confidence. It must be something that's already a secret, something that people don't know about before it can be protected. So they said examples of information relevant to computers, which may be the subject matter of confidence. It says one, ideas for a new or improved computer system. Okay, e.g. hardware, software, just all those things, ideas of how you want to develop it. Like let's say Facebook, you have an idea, like before they started Facebook, Mike Zuckerberg actually wasn't the one who had that idea. The idea belonged to twin brothers, forgetting their names. They were the ones that had the idea, and they called on to Mark Zuckerberg to come and help them to program, because he was a really, really good programmer. So when he had the idea, he now started making Facebook for himself, using the idea. But actually, it became a court case, a serious court case, because they sued him and all that. But he paid them off at the end of the day hugely. So that's what I'm saying. Like these things, like the ideas. If someone breaches them or whatever, you can sue. So that's by the way. The second thing, the details of an existing computer system, as will be known by computer analysts or programmers or even users of the systems. That is, I'm listing out the things that can be protected by the law of confidence in our computer science world. The third one is databases. Databases that might include consumers, customers' names, suppliers or contractors, and associated information. For example, like what customers' credit ratings are, what they have ordered in the past, and how they paid, their goods and services, their information. All those things are supposed to be kept secret. You don't go exposing your customers' credit card details, house addresses, all those things. So those things can be protected by the law of confidence. And the last one is a company strategy for future research and development, production and marketing. Those things are supposed to be kept hush-hush. So things like that can be protected by the law of confidence. Now, a major weakness about this law of confidence is that it cannot be imposed on everybody. It can't be imposed on everyone. So a person who is giving confidential information, for instance, but the person is unaware that this information they are giving to them is of confidential nature because they were not told, that person cannot be sued for breach of confidence, because in the beginning they were not even in the know that, oh, this information that they're telling me is a confidential one, is of a confidential nature. So that's the problem with this law of confidence. It cannot be imposed on every single person. Moving on, we have let's talk about photographs and other images of individuals. So as a basic rule, it is a breach of confidence to publish a photograph or film of an individual, okay, without the person's consent. You see, they do this a lot in Nigeria, where you go online, you see they've somebody will just, maybe for ratings, for clout or whatever, they'll just post a video of somebody, maybe a girl that was maybe in church, she was praying fervently, maybe she has her own issues, she's talking to God, crying and all, somebody in church will video her, now come and send to Insta blog. That is wrong. Those things are wrong. You don't share people's photos without their consent. You don't even record people without their consent. You don't do that. Like I said, in a sane environment, in a sane society, nobody does that. Abroad, you will be sued, and sued heavily for breach of confidence. So let's see what else we can talk about. So the law of confidence as applied to employees that's in the workplace, as applied, generally the duty of confidence owned by ex-employees will be less than for that of current employees. So what that says is, now just imagine you are working for Shell, okay, and now you're fired, you don't work for them anymore. Tell me, do you think you owe them any like, you keep their secrets? If somebody comes and asks you questions, you think you owe it to them to keep everything hush-hush? You really don't owe them anything. But for someone who is currently working there, you don't go about talking about your establishment where you work for. So you owe them. That's why most companies, before you get employed, you sign a lot of papers, you sign a lot of non-disclosure agreements, you don't reveal information about the company and all that. So for employees, you do that, but for ex-employees, you don't owe the company anything. So now there's this thing we talk about whistleblowing. I'm sure you guys have heard about that. So they say there's an Employee Rights Act that has provisions protecting employees making certain types of disclosures to his employer or any responsible person. For example, is disclosure showing a breach of legal obligation or the commission of a criminal offense. This is often referred to as whistleblowing. So there's actually an Employees Rights Act that protects employees from whistleblowing, like if you're working in a company or somewhere and you know they are doing something very terrible, maybe they are killing people or they are doing something, there's actually an Employees Rights Act that protects you for breach of confidence, because if you go and expose your company, you're breaching confidence. So there's an Employees Rights Act of 1996 that protects you for that. Then who is a computer hacker? A computer hacker is a person who gains access to a computer system without permission. So computer hackers pose a serious threat to the security of computer systems, and some of the activities in which they engage in are potentially criminal in nature, because if a hacker gains access to your computer or your phone, they can steal a lot of things. Most of us have private pictures, private videos. They can also steal like your bank information, log into your account, steal your money, so many things and all. But say if a hacker gains access to confidential files stored on your computer, the law of confidence might be used to prevent the hacker from making use of the information or further disclosing it. But then again, that's in a society that is working, not in Nigeria. You know how it is. They have access, they get access to Instagram, they release your photos, they do all sorts of things. There's no law of confidence in Nigeria that is protecting you from that. If the information is accidentally overheard or intercepted in circumstances where the owner of the information alters it or transmits it by insecure means, for example, by telling it to someone in a crowded room or by transmitting information by using a public telecommunication system, then the obligation of confidence might not be imposed on that. So if your information is spread by these means I just mentioned, where it was by accident, maybe somebody overheard when you were telling another person, or if maybe you were sending your important confidential information via a computer network that's not secure, then the law of confidence cannot protect you there. Then you know what a spyware is? Information obtained through the use of a spyware. A spyware is a software that is usually placed surreptitiously on a computer, which then transmits or enables the transmission of information to another person. So if information obtained through that means of a spyware, it will be obtained in breach of confidence of information itself has the necessary quality of confidence about it. So if someone steals information from your computer by placing a spyware, and information they stole has the quality of confidence that we talk about, then that means there's a breach of confidence, and then the person can be sued. You can sue the person and claim damages. Now here, what are the remedies for breach of confidence? The most important remedy for breach of confidence is an injunction preventing the use or disclosure of the information. So injunction is something that stops you. So an injunction will stop you from spreading that information or using it. So that's the most important remedy for breach of confidence. But if the information has been divulged to sufficient people so that it can be said to be no longer confidential, an injunction will not be of any help in that situation. It will be like just locking the stable door after the horse has been bolted. You see, it's like you are already losing the horse in the stable, but it locks the horse will just break through. Horses are very strong animals, they just break through. So that's just a metaphor we're using here. So if this has happened and information has been used to the detriment of the person to whom it belongs to, however, damages will be available against the person responsible. Like I said, again, in a sane country, in a sane environment, a sane society where this justice system is working, yes, if you release someone's information without the person's consent, the person can sue you for damages, and the person will get paid. You will have to pay the person. The court will make you. But so another alternative to damages is an account of profits may be available, and this may be more advantageous to the claimant. Accounts of profits is just a type of remedy most communities most commonly used in cases of breach of confidence. It's a type of remedy. So that's about it. In summary, the three ingredients of breach of confidence are: one, the information must have a quality of confidence about it. Two, the defendant must be under an obligation of confidence. Three, there must be an unauthorized use of the information or a threatened use. Information protected by confidence can include source code for computer programs, databases of customers. That's just an example. Then an obligation of confidence may be express or implied. So there you have it. Okay, just know this. Okay, this is a straightforward topic. I'm just telling you the basic. Like I said, we're not in law school, or we're not studying law, we're studying information technology law. So we talk about these things in relation to our computer science um, field. So this is the second video. I will make the third video. So just read through everything, and if you have questions, like I said, you write it. You ask me under the video in the comment section, and I'll reply you if you have anything that you don't understand. So see you in the next video. Thank you for listening. Bye.